Welcome, everyone, to the Legacy Lawyers Podcast. I am your host, Nathan Croxford, and joining me today is Brian Edwards. We're doing it again.
That's right. Hello.
How are you,
I'm
Brian?
back. I'm doing great. Just
Good.
living the dream. Summer.
Are
What
you
else than
are
that?
you melting?
Yeah, it's hot. We're in the middle of summer, doing this one today. I think this week alone we've been swimming as a family. Like, my kids have gone at least every day. I've gone twice already. Like, it's hot.
Because
But
you have a pool in your HOA?
we do, yeah. We're lucky to
No,
have
that's
that.
nice.
Yeah, it's been great.
At least it's a dry heat.
That's true. Yeah.
We were over 100, I think, and we're going higher, but if it was like 70% humidity, 80% humidity on top of this, even 30, 40% humidity, it would be way worse. So,
I agree. Yeah. I agree.
well, before we start, let me just give our disclaimer for the podcast. Brian and I are both estate planning attorneys, and we do practice in this area on a daily basis. But the purpose of our podcast is edutainment, educational and entertainment purposes only. So I would say, for the most part, we're never giving legal advice, and we're not giving anyone specific legal advice, but if ever there was a podcast where what we're going to say is probably applicable to almost everyone listening, it would probably be this one.
I
So
would agree. Yeah.
I think we can confidently say that. But that being said, please do not rely on this information as legal advice. Please see someone who is a qualified licensed attorney who can help you with your specific situation in your specific jurisdiction. You're welcome to give us a call or contact us online. We can either help or we can direct you to someone who can. So, with that, Brian, what are we going to talk about today?
Yeah, today, like you said, it probably will touch everybody. Right now, comparing you and me, you're much older than I am. This
Hey,
affects you probably much more than it affects me right
hey, hey,
now.
hey, ease. Whoa. Jeez, Louise.
That's right.
Come out swinging.
That's right. Yeah, I mean, we're
How
talking
old are
about.
you? I always, the way I describe it to people when they ask me, well, what happens if you die? I say, because that's a question we actually get a lot when we're talking to clients, right? Is
Yeah,
we're spending hours talking about what would happen when they die, and some of them go, well, what happens if you die? What happens to my plan? The answer is no attorney's plan should be dependent upon their still being alive, practicing law, being at the same firm. It's nice, and you really want a firm that has that kind of stability, but eventually one day I will hang it up, and eventually one day I will too meet my end, as we all will. And
yeah.
Brian's saying it's going to happen anytime,
Could
basically.
happen anytime for you. Yeah.
So when people say that, I always say, well, I have a law partner who's 10 years my junior. The other attorneys are just disgustingly young. I don't even want to know how old they are because it just makes me feel old. So I honestly don't know how old you are. How old are you?
I'm 36.
Yeah, see, come
Yeah.
on.
It doesn't feel too young anymore, but I mean, we're getting there.
Well, talk to me when you hit the big 5-0,
Sounds good. We'll do that.
and
So
then we'll talk about how young you felt when you were 36.
there we go. I'm okay with that.
Yeah, so it does kind of impact me more than you because we're going to talk about what happens when a child turns 18, which in every jurisdiction in the United States, the child is no longer considered a minor for most things. They are of the age of majority, they can vote, they can join the military. Um, they cannot yet in our country drink alcohol legally. There are probably some other things that don't quite happen until 21. And I can tell you, and maybe you've noticed this as well, but we kind of have a joke around our house and in our extended family that a child that's 18 or 21, while an adult is, we refer to them as marginal adults or nominal adults. Adults in name only. They're basically a teenager that got more rights, right?
That's right.
By virtue of aging a little
That makes
bit.
total sense.
Yeah. So why is this an issue?
Yeah, what happens when a child reaches the age of majority, which again for most states is 18, including Utah? They are a legal adult. All of a sudden, all of their records, medical, school, their bank accounts, and everything, that all transfers. That if somebody needs to access it, it is that child's because they are the adult now. They are the ones who can access it, and the only ones at that point who can access. Parents start losing that access. I mean,
Yeah, and it's sudden.
but just by the fact that they aged out, I guess, of minority.
Yeah, and it happens suddenly. So I will give you a real world example. My daughter, who's over the age of 20, not by much, but she's still, well, she's lived out of the house. She usually will be gone during the school year. She's not going to college, but she goes and lives where her friends are going to school. She has her nail tech license, so she's really good at putting fancy fingernails on anybody who asks her. I've never, even though she's asked me to do my nails before, I've never allowed her to do it
I'll
because,
tell you right now, my 6-year-old daughter would love to meet her. My
yeah,
6-year-old daughter
yeah,
would
kids
love nails.
love to have the pedicure, love to have the manicure, love to have their nails painted, love to have the fake
Oh
nails
yeah.
put on. There's probably a better word for fake nails. But anyway,
What? You're good.
she had a medical situation. Could have been serious, but thankfully was caught early. And we kind of found out the hard way that she was about 2 years past the point where we could just call and expect to get information. We were waiting on results of a test, and when the results of the test came back in, Shannon, my wife, called to check in on those results, and she was told, "We cannot release that information to you." And I think she said something along the lines of, "Well, we're still the financially responsible party. We're still paying for these medical services you're providing." And that didn't matter either. So essentially, my daughter had to call and get the results. Now, it doesn't have to stay that way, and we subsequently found a fix for that, which is what we're going to talk about. But we found out real quick that there are some things that every parent should do in order to be able to continue to have access to their child's medical records, their educational records, their financial records. And so today we're going to talk about 3 documents that every 18-year-old should have, and anyone above the age of 18. So,
Yeah. And just, I mean, in your situation, kind of from the law side, I guess what you can say is the law that stopped you and your wife to be able to get the documents, it's called HIPAA, or at least that's the short version. The long version, if you want to know, the Health Insurance Portability and Accountability Act. But this is a huge law, but it's the law that, as I explain to clients, it's the law that says only you can access your records. Like they will only give them the health, or like the doctors, the hospital will only give it to you as the patient. That's the law, and that's what it is. It's a good law. I'm not saying it's a bad law. We don't want anybody just to come in and ask for records and for anybody. But that's that one. There's an educational law as well called FERPA, and I could tell you what it stands for. The Family Educational Rights and Privacy Act. That just says that, in school, that the only person that is school, like college, will release records or about the school to is the student. That's another law that's out there that, and again, we like the law. We don't want anybody just to come in and get school records for anybody. Like, we want to make sure that it's going to the person that is requesting it, that it's their records. So,
yeah, and if I'm not mistaken, I don't think it's limited to just colleges. Like if I were to go back to their elementary school or to their junior high or to their high school, middle school, whatever you have in your area, and ask for those records. I think the systems where those records are kept would pop a notification that this person is now over the age of 18, FERPA is in effect, and we need the institution needs proper authority to release those records to anyone other than the student. So
Yeah, yeah. And so, I mean, those are just the laws that we're dealing with here, and then just again, by the fact that they turn the age of majority, banks are gonna stop giving information out only to the person that is an account holder, things like that. So again, this is kind of the laws that we're dealing with. 3 documents. Yeah, you mentioned them. I'll give you the broad view if you want, and then we can hammer.
Okay, sounds good.
3 documents that we're going to talk about today: a HIPAA waiver, a healthcare directive, and a financial power of attorney. Those are 3 documents that every 18-year-old can have and can sign legally that would be able to help the parents be able to still access records, especially medical records, to be able to help their kids as they continue to learn about adulthood and become not just nominal adults like you said, but like adults, I guess you could say.
Full-blown,
Yeah.
bona fide adults.
Yeah.
Right. So, yeah, I mean, there are a lot of circumstances too where kids are leaving home at that age, whether it's they're leaving to go to college, they're just simply moving out of the house to live with roommates. They might be getting into serious relationships where they're cohabitating or they're marrying and establishing their own households. In our part of the country, kids at that age, a lot of kids at that age are leaving on church missions. I know that there are a lot of kids that go on long humanitarian trips they're gone for a summer, they're gone for multiple months at a time.
Yeah.
There are also kids that move out of the country to become an English teacher or to do humanitarian work for charities that help, countries that are having setbacks or that they just have vulnerable populations. So there's a lot of ways that the kid could be out of your home and you need information, and if you don't have these documents, you're going to run into a roadblock. And even if they're still living at home with you, they might, like when we were trying to get these medical records, my daughter was still living in our home, but she was at work that day and we needed to find out what was happening, and we really couldn't. So why don't you tell us, should we start with, because we kind of went in an order there, should we start with HIPAA?
Yeah, let's do that.
Okay, so what in the health arena, what are we talking about?
Yeah, when it comes to this, we're trying. It's a situation that you brought up, where the child has gone to the hospital. They're in the hospital, even like dental records. Or whatever. Anything that's health related and to document.
Labs. They had labs drawn. They're not going to release it to you.
Yeah. All of that, all these health records, there's just not being able to, you just can't access them. So we do a HIPAA waiver, which is literally a document where somebody can say, hey, these are the people that I want to be able to get through HIPAA, like they're waived, they can access my records. So it's a really simple one. It's just a list of people. And then we obviously say like they can get access to all these different records. They're generally said medical records. To be able to, somebody on the list can call the hospital, call the dentist office, call the labs, call whoever they need to be able to get the results that they need to figure out what's going on.
Yeah, and there's a couple ways to do this. I think probably everybody would want to have just a general HIPAA waiver prepared by an attorney like the ones that we do here at Voint Legal that could basically be sent to any, healthcare provider and would probably fit the bill. But I'll tell you from experience that sometimes the quicker way is to actually ask that institution for their HIPAA form. And there's nothing wrong with having both. You can have a particular provider, or if you're in a network, there are a couple big healthcare provider companies here in the state of Utah and in the Intermountain region that if you've completed a HIPAA waiver for that particular company. It's good throughout all their providers. But I found a lot of variation between doctors' offices and so forth on that. So sometimes maybe a particular doctor says, no, our policy is that we have to have a HIPAA waiver specific to us. So we have done both. We have the general HIPAA waiver for our two children that are over the age of 18, and we've also completed, or I should say, our children have completed the institution-specific ones. And the key here is that, I mean, I can draw it up. I can, if I'm a parent who's a client of our firm, I can request that that be done as part of my planning, or I can actually, you know, as my children age into that scenario, I can call and say, hey, we just had a child turn 18. And this would be our advice, right? Our recommendation would be, as soon as they turn 18, get this in place. But it's been a really useful thing to have, and it just makes it easy so they can just check who's approved. But ultimately, the child themselves, who's now an adult for this purpose, has to be the one signing that waiver, giving the permission, right?
Right.
So it does take some cooperation. And it's a lot easier to do this before your child has left home than trying to coordinate across state lines, even within a state, across county lines, different cities, especially across, you know, country boundaries. You might have trouble finding a way to get something notarized if you're in South America, or if you're in Africa or Europe or wherever you might be. They have different requirements for that.
Yeah, I'd agree. While they're home, while they're still 18, even if they're in high school, because we have 18-year-old seniors all the time. That's fine. That's totally fine.
Yep, get it done.
Yep.
So HIPAA waiver, that's the first one. What else?
Second one, a healthcare directive. I know that I've talked about the healthcare directive on this podcast with Mike before. It's simply, quite simply put, it's a document that you can say, hey, if I become incapacitated, I want this person to act as my representative for healthcare decisions. And the Utah's form, it can list out a couple of things where you can make some decisions on what you want to do for like food and fluids and medical care and things like that. But ultimately what it comes down to, for our purposes today, this is somebody that can act on my behalf. Like that's the really key principle here. Like if, you know, child is out of state, gets in a car accident, it's in the hospital in a coma, somebody wants to be, the parents for sure want to be there to be able to say, hey, this is what we want to have done for a child, or, you know, and be able to make some of those decisions, not just have the doctor make them, but to be part of the conversation. And this is the document that does it, that allows for that. There are HIPAA provisions, at least the ones that we draft have HIPAA provisions, but beyond that, like it goes and says, hey, this is who's going to be there to take care of me and to make the decisions for me.
If you weren't 36 years old, you would remember the days before states had kind of codified and created these nice specific forms. And back in those days, attorneys would have to put together kind of a combined document that was called a healthcare power of attorney and a living will. And an advanced healthcare directive is basically taking those two concepts and combining them into one document. So you're naming an agent, basically an agent under a healthcare power of attorney, to be able to make healthcare decisions for you and speak for the child, and be able to speak on the child's behalf if they're unable to direct their own care. The child who now is an adult, the adult child. So this could cover, as you said, like anything from, you know, they've been in an accident and it's a short-term recovery, but for a period of time they're not conscious or they're not able to direct their care. Mom and dad can be listed as the parents. Any combination of parents can be listed as the agent for making those healthcare decisions, which could include anything from, a lot of people when they hear this, they think, oh, they're talking about the pull the plug document, right? Yeah. And that's true. There is some end-of-life provisions there are some end-of-life provisions in these documents, but it doesn't necessarily have to be just end-of-life. And then the living will portion is you get to give, the person completing this, the adult child filling it out, gets to make some preset decisions and give some direction to their agents as to how they would want certain types of scenarios handled. They're not perfect, but definitely better than not having anything at all. So,
Right.
an important document.
Yeah. That's the second one. We'll move on to the third one, which is a financial power of attorney.
Hmm.
Acts, well, I shouldn't say acts the same way, but it's similar in that you are going to name an agent to act on your behalf for financial and legal decisions. Should anything come up and we need to get access to accounts, bank accounts in particular here, or be able to do really anything on your behalf to help you out. And those ones, I mean, again, we have one that's pretty robust, but they can be, I've seen some pretty simple ones out there, some pretty robust ones, but it's really, again, just this idea of we want to give somebody the power to make these decisions for the adult child if they cannot make them themselves.
Yeah. Yeah, and there's a couple ways we set those up. One way that we set those up is to be springing. So if you've ever heard the term springing power of attorney, what that means is the adult child has named an agent, but that agent's powers are dormant unless and until certain conditions are met. And generally, the condition is, have they lost capacity to manage their own affairs, whether through illness, accident, disability, absence, right? I don't know, absence, that's an interesting one.
Going on a backpacking trip to Europe.
Yeah, I guess in a scenario where somebody disappeared, maybe that would be the case. But what I would say is the other way that we go about setting these up is to say, I'm naming an agent and I'm authorizing them to act on my behalf right now, effective immediately, without proof being needed that I'm incapacitated. And I think for somebody that is leaving the state, I don't know. It's going to be up to the parent and the children as to whether or not they want that to be springing or they want that to be immediate. In our particular situation, we made ours effective immediate, just so that we don't have to jump through the hoop of proving incapacity, which at a minimum is going to require that a doctor write a written letter, an opinion saying that I care for this individual, and based on my knowledge of their medical situation at this point in time, they are unable to manage their own financial and legal affairs, and therefore they're considered incapacitated at this point in time. As the child ages, you might change that up, right?
Yeah.
A child might say, now I've got a significant other, I've got a spouse, or I just only want this to be in effect. I can manage my own stuff now, and I do manage my own financial and healthcare affairs, but I would still want help from mom and dad or siblings or other trusted individuals if I was incapacitated. Very easy to just change up that particular provision and re-execute the document to make it springing rather than immediate.
Yeah.
So yeah, that would be, when I say power of attorney in meetings, almost immediately people go to, they think that's the healthcare power of attorney. And I always have to clarify, there are more than one types of power, more than one type of power of attorney, and we've covered them both now. So the general durable financial power of attorney is the one that now. So a little bit different, same, works in similar fashion, but the healthcare directive is specific to healthcare decisions.
Yeah. And just to make a point, I mean, all three of these documents are amendable. They can all be changed later on, not just the financial, but all three of them, as you said, as kids age and circumstances change and more people come into their lives, any of these could be changed at any moment.
Yeah, the other thing I'd say is that these documents also die with the person. So sometimes people mistakenly believe that a power of attorney, they still have power of attorney for someone after they've died. That is not true. So the second a child has children or owns real estate or owns any significant amount of property, then we're talking about, okay, we need to upgrade their plan from just being an advanced healthcare directive, a HIPAA waiver, and a general power of attorney. They maybe need a standalone will, or they need a trust. It's going to be very situational dependent, fact dependent based on their situation, but don't get caught in the misconception that these documents would allow you to do things on behalf of your child if they were deceased. And the one last thing I would say, and then I think I've covered everything I've got. But is I'm also old enough to know that this starts to be an issue for adult parents as they're aging. So I've got, at the same time as I've got marginal adult children who we now need these documents in order to access information on their behalf without their being there or being the one requesting the information. We've also run into situations where my parents, they had a springing power of attorney, right? And very suddenly we realized they were now to the age where we needed that to be an immediate power of attorney. Like they're not incapacitated, but they are aging enough that depending on the day, they don't feel great. They don't want to get out. They're not healthy enough to get out. This is, anybody that has aging parents knows what this is like. So we had to, in fact, my parents' planning is sitting right here on this credenza because we're in the process of updating their power of attorney to be effective immediately. And we also changed up the order of agents on the healthcare directive because of who lives more approximate to my parents. So it used to be just in birth order. They had us named as backups to each other. But now I have a younger sister that's taking over a lot of their, taking them to doctor's appointments and needing to access records. And so keep that in mind as well.
Yeah, that's a good point. I think the last thing that I want to just mention, I had mentioned FERPA. Let me just wrap it up a little bit. We don't, at least at our office, and probably not necessary for an attorney to have to draft like a FERPA waiver to try to get access to school records. But just like, each, as you mentioned, like a hospital may have their own HIPAA waiver or their own thing. You can check with the college or the university where your children are at. And if, again, they're adults, they have to sign it, but there's probably documents that the college has that it can be filled out to be able to get access to school records if that's a concern as well.
Yeah.
So
Yeah, and probably something that you do as you're doing campus visits with your child, and when they decide where they're going to go to school, that'd be a good thing to request and get that lined up and get it executed and turned back in so that you don't run into a situation where you need something quickly and you've got to go through the whole process of getting it signed, and maybe they're not local, and so it can be a problem. So,
yeah.
Okay, well, thanks for joining me today, Brian. One day you will know what all of this is actually like. At this point in time, your children are nowhere near this age.
Actually, we had a situation where I was not listed as an adult, or I wasn't listed as the parent of my daughter.
See, so that's what happens when you're young enough. Sometimes people don't consider you an adult.
That's right. So, but I wasn't listed as the parent, and so I tried to call to
Oh my gosh.
and they wouldn't give me any information. So I had to have my wife call and say, no, this is my husband, this is the father. Please talk to him. And so
Wow.
anyway,
Okay.
it has happened to us, but we didn't need the HIPAA waiver to get access. We just needed
Yeah.
communication. So.
Well, I will say one last thing for your benefit as we depart. This will happen faster than you can even imagine. So don't sit there and think that because 15 years are going to go by in the blink of an eye, and you will be blown away at how quickly this happens. So just keep that in mind.
I'll draft their documents today for my kids.
I'm not saying that. I'm saying take advantage of every minute you have with your littles, because you only get that opportunity once and it goes quick. But yes, I would say maybe on their 17th birthdays, start considering putting those documents together.
I like it.
You do it now, the healthcare directive might be completely different by that point.
That's a fair
So,
point.
and just to be clear, they can't sign it until they are 18. So
That's right.
don't have them pre-sign because it's not going to be valid.
And again, it's just as one last clarifying note, the age majority in the state that you're in. Utah, it's 18.
Yes.
I know Nebraska, I think Nebraska's is 19.
Really?
So yeah, I think most states are 18. I don't know across the board, but I remember in Nebraska when I went to school out there, like it was
Interesting.
So
Didn't realize we still had differences between states, but check into that.
I mean, that was a couple years ago. So if you're in Nebraska listening to this, go check.
Yeah, don't get mad at Brian if he's wrong. It just means
That's
he's
right.
been away from the state for
It's been a minute.
for a few minutes. So
Yeah.
that's where he went to law school, if you're wondering.
Yeah. Creighton University. Go Blue Jays.
Go Utes.
There we go.
Hey, thanks for joining us. Check us out on all your major podcast platforms. Have a wonderful rest of your day, and we will catch you on the next one.
Thanks.
You've been listening to Legacy Lawyers with Michael Haslam and Nathan Croxford. We give you the juicy detail of cases that our law firm has dealt with. We take out the lawyer talk and legalese and show you what options some of our clients had to choose from to fix their situation. The effects of not doing planning can be devastating. We'll be back soon, but in the meantime, hook up with us on Facebook and Instagram at Voyant Legal. Call us at 801-951-0500 or send us an email at team@voyantlegal.com. And for commonly asked questions, hit voyantlegal.com/resources. We'll see you next time.